Yes, apologies for the slight delay, Mr. Hussain.
Not at all, my lady. My lady, so our first cross-appeal ground, due process, addressed at 47 to 67 of the divisional court. In our submissions, it's addressed in our cross-appeal submissions, paragraphs 4 to 21, and in our reply at paragraphs 2 to 9. May I please address you on three broad topics. Firstly, pretty quickly, the legal principles. Secondly, the application of those principles to the facts here. And thirdly, I'm going to try to draw together the ways in which the court erred in this case.
Okay, but we would like you to finish by 2:35, no later.
Oh, yes. Okay, so part one, legal principles. 4 preliminary points, please.
Yes.
1, the starting point and fundamental rule of the common law is that a person adversely affected by a decision, certainly with draconian effects, is to be informed of the case against them and given an opportunity to answer that case by evidence. It's a fundamental rule in the sense that it is one of the oldest principles of the common law. We'll see that from Lord Sumption in Bank Mallet. It is a rule that's so important that its abrogation must be clear from the legislation, Lord Neuberger and Bank Mallet, and indeed ouster can only arise in the statute by way of necessary implication, something that is different to expediency, even desirability, or even reasonable implication. See my lady in Begum. Where the statute hasn't ousted, it will be rare that the facts do so because of the importance of the duty. Lord Neuberger in Bank Mallet. The second preliminary point, I've said that it's important and what that means in terms of statutory construction. Why is it important? Very well known, Osborne. Firstly, instrumentally, it produces better decision making. Secondly, it treats the individual with respect and dignity. Lord Reid citing Jeremy Waldron. And thirdly, it promotes the rule of law. Lord Reid citing Lon Fuller. The third preliminary point is whether procedural fairness has been observed is, of course, a matter for the court to determine for itself, not a matter for the judgment of the executive. You have what Osborne is one of the cases you don't have, but it's in Osborne at paragraph 65, obviously perfectly obvious. It's within your institutional competence and indeed your constitutional responsibility to uphold the rule of law. Fourthly, it is an important part of the legal landscape here that the court held in the preliminary issue on alternative remedy that sections 4 to 5 of the Act are not, quote, and are not intended as a means of challenging the lawfulness of the initial decision to prescribe. That's your judgment, core bundle, tab 24, in the hard copy, page 179, AL, page 179, AL, in the PDF soft copy 316, paragraph 51. This is important because, as we will see, the availability of a statutory appeal to SIAC was central to my lady's conclusion, my lady's apostrophe conclusion in Begum as to why the standard and fundamental rule didn't apply in that case. It's also important because the Secretary of State strongly relied upon those sections, POAC, both in submissions and in evidence. In her contention that the statute ousted the fundamental rule, it's the first point made in her detailed grounds of defence, paragraph 82C core, bundle 25, tab 25, page 213 hard. E is 367, thank you, Mr. Luckhurst. Soft is 367. It's also relied upon in Mr. Sinclair's second statement, Sinclair 2, paragraph 8, supplementary bundle 1, tab 4A, page 42D hard, 46 hard. What's it in hard? Oh, sorry, 42D hard, 46 soft, sorry. They say, POAC. If you strip away that erroneous premise of POAC, we can see that there's nothing in the statute that ousts necessary implication, the fundamental common law rule. Those are my 4 preliminary points. 2 authorities, Bank Mellat and Begum. Bank Mellat, please, can I ask you to take it up? It's in Authorities 1, tab 22, page 696. So at the beginning of the judgments in the main appeal, not the closed material procedure. You just give me 1 second.
Paragraphs 29, 30.
696, sorry, I have got the right reference, I'm sorry, it's completely my fault. So the context is, you will know, financial restrictions designed to counter nuclear proliferation, 6-3 majority decision that the Treasury's decision was vitiated by procedural fairness. As usual, my lady is ahead of me. Paragraph 29, yes, the duty toward assumption. Sorry, I'm going completely. Yes. Yes, paragraph 29, apologies. Duty to give advance notice, opportunity to be heard against a person against whom a draconian statutory powers to be exercised, one of the oldest principles, and then citing Cooper.
Then it's our fault, but we are finding it difficult now to locate which paragraph you're currently reading in Bank Mellat. I'm so sorry.
I'm sure it's my fault.
29.
39.
29.
29.
29. 707. Oh, so these references. Okay. Thank you.
29.
Paragraph 29. Page 707, thank you. And then paragraph 31, page 708, paragraph 31, unless the statute deals with the point, the question whether a duty or prior consultation cannot be answered in wholly general terms depends on the particular circumstances. And then paragraph 35, the duty of fairness governing the exercise of the statutory power is a limitation on the exercise of the decision-maker, discretion of the decision-maker, which is implied into the statute. The fact that the statute makes some provision for the procedure to be followed before or after the exercise of the power doesn't of itself impliedly exclude that duty. And then at paragraph 37, Lord Sumption, JR doesn't exclude. It would be surprising if the statute did. We're a fortiori, of course. And then I'm going to jump forward, if I may. That's all I need from Lord Sumption. I'm going to jump forward to Lord Neuberger at page 750. And this is paragraph 179
So that one's
of the judgment. Now, this is important because this was common ground that this is the test, this represents the law, and my Lord Justice Edis will recall a case in which the Secretary of State sought to draw clear blue water between Lord Sumption and Lord Neuberger, and your Lordship held no difference. 179 is controlling. It's the case of Timpson, in which your Lordship held that some time ago.
Right. Thank you for reminding me.
179. In my view, the rule is that before a statutory power is exercised, any person who foreseeably would be significantly detrimentally affected by its exercise should be given the opportunity to make representations in advance unless, one, the statutory provisions concerned expressly or impliedly provide otherwise, or two, the circumstances in which the power is to be exercised would render it impossible, impractical, or pointless to afford the person such an opportunity. And then you've got to be slow to do it on Roman 2, given if you've got to that stage in Roman 1 hasn't been excluded. And then just going forward to 191, para 191, page 752, letter G, just above letter G, at a high level, I consider that while the right to be consulted in advance about the exercise of a statutory power which will cause significant harm can be abrogated by implication or statute in the statute, that right is so important that the implication must be very clear. That's all I want to take from Bank Mellet. National security context, affirmative resolution procedure, statutory instruments not relied against us. Clearly, due process applies in both those contexts. 6-3 majority. We now go to Begum, please, if I may. Case which will be well known to my ladies. That's Authorities tab 37, Authorities Hard Volume 2, tab 37, page 1309. And you'll see how the issue is framed. The case, of course, is one of those unusual cases where the provision of a merits appeal combined with the legislative purpose and context in which deprivation decisions on national security were typically made, people who were abroad who might preemptively come back, meant that there were, quote, compelling reasons for holding that the basic common law right to be heard was impliedly excluded. You'll see how the issue is framed. It's framed in line with Lord Neuberger at 191 in the implication of ouster must be very clear at 104, where you're dealing with 104, page 1339, you're dealing with ground for a due process. And you look at the proper approach to statutory construction, letter E, asking ourselves whether Parliament has by necessary implication excluded a right to prior representation. Then you cite Morgan Grenfell, Lord Hobhouse, the legal professional privilege case, powerful, pithy expression of what that means. It's a matter of logic, it's not reasonable. Necessary is something much more than that. at paragraphs over the page 106 to 107, so sorry, bottom of the page, and over the page, a main, if not the main purpose, which displaced the common law rights so that the general rule was no prior consultation. National security in general was the main purpose, but it was important to see how that main purpose was to be implemented. Deprivation decisions in the context of people abroad, to notify a person abroad of an intention to remove their citizenship could obviously act as an encouragement to that person to return to the UK preemptively. The very act of seeking representations would be contrary to the national security of the UK. The individual would take immediate steps to return. So it's in that context that the general rule is endorsed. There's no general rule that in national security across the board, wherever it might be engaged, there's a general rule of no due process right. That would, it's wrong. There's no case which says that, and B, it's inconsistent with Bank Mellet and Lord Neuberger. That is a national security case. But in other words, in Begum, the relevant risk was of preemptive action to deprive the order of its effect, travelling back to the UK while the individual is still legally able to do so, so that the objective of keeping him or her out of the UK is frustrated. The same logic just doesn't apply here. Whatever Palestine Action did in the intervening period, they would be subject to the very same consequences on prescription as if they had not been consulted. There's no analogy with travelling back.
You say Palestine Action has to be consulted, but I understand it's not a body.
I'll address you.
The question is, which
My
person
client.
or person?
My clients.
One of the two co-founders or both the two co-founders?
One would be sufficient,
Right.
yes, and they knew that they were spokespeople. The email addresses were there in the press. I'll address you on that. There's no analogy with travelling back, as in the UK deprivation cases, by which to contend that prior notice would risk depriving the measure of its intended effect. The context is that surprise was of the essence and paramount. There's a huge contrast here because the statute contemplates notice, except not in the common law rule sense, but except in urgent cases, because it says affirmative resolution only effective if approved by both houses, save in urgent cases. So the statute distinguishes between cases it regards as urgent, immediate effect, unless disapproved by both houses, and the standard case. And we are in the standard case territory. There's a point, in fact, that Mr. Justice Swift made an argument. I was looking at the transcript, where he ruled against us, but he said, look, the statute contemplates time that the group is aware it's going to be prescribed. There's very different statutory context from Begum, where surprise is of the essence. And you set that out at 108 to 109. 109, SIAC had agreed that the statutory code wasn't enough. It applied simplex, it applied we don't need to get into that, if you remember. And you said, in the light of Bank Mallet, that might be so, that it wasn't enough to exclude. You place critical reliance, we submit, my ladies, critical reliance on the appeal to SIAC, because they had underrated, quote unquote, it underrates the distinctive nature of an appeal to SIAC. It's absolutely critical that you had that appeal to SIAC in this decision. And then at 110 to 111, you discuss SIAC, and then at 112, you said the existence and distinctive nature of this right of appeal and the risk of preemptive action by the appellant, if prior notice given, remain, in our view, compelling reasons to construe the statute as excluding the common law rule. 3 points of distinction. POAC, not an appellate merits review, it's JR. It's not available anyway. Secondly, no analogous risk. Thirdly, no compelling reason to exclude in the statute. Indeed, on the contrary, the statute contemplated notice, the reasons I've given. Topic 2, I'm going to speed up. Topic 2, application of the principles to the facts. Lord Neuberger, 179. No express ouster, no statutory appeal, no necessary implication, we say. Do the circumstances mean it's impossible, impractical, or pointless? No. 4 points. 1, who to consult? Our cross-appeal skeleton at 19, please. You just have an eye on that. My client is co-founder. JTAC assessments show that she's viewed as a spokesperson, one of the spokespeople for the group. The references at paragraph 19 of our skeleton, and they're twice described that. Making contact would have been straightforward. We make the point in our skeleton at paragraph 19 that Palestine Action provided an email address for information and query. Second point, what information and allegations could be put? We can see from the extensive open disclosure in these proceedings that this wasn't a case in which national security prevented the Secretary of State from putting the gist to my client. Third point, the factual chronology shows that proscription wasn't treated as so urgent as to render consultation impractical. We've set it out, the chronology, with cross-references at paragraph 17 of our cross-appeal skeleton. Direct action 5 years before, last incident in terrorism, August 20, as assessed as terrorism, August 24. And then most saliently, even when the decision is made, on the 20th, the written statement is put into Parliament as announced 3 days later on the 23rd. So it's in the media on the 20th. If you don't accept that, it's there announced on the 23rd, on the Monday. A draft order isn't laid until another week, and then it's not passed into law for about another week on the Saturday, the 5th of July. So we've got 2 weeks where we know. On the facts, this was not approached with any urgency or on the basis that surprise was of the essence. Fourth point, as to the risks of preemptive action, this isn't a Begum-type case. This is my fourth topic. First point, not Begum-type case. Secondly, I've already made the point that we had at least 2 weeks' notice. Third point, no specific evidence of a risk of preemptive action. Secretary of State, in her skeleton, relies on a generic issue in the explanatory memorandum. Sir James also relies on Sinclair 2. Again, that's entirely generic. In his oral submissions below, he talked about a possible issue regarding the movement of funds. In evidence, that's the generic issue that's made. That hasn't reappeared before you. But in any event, we know from the open material that Palestine Action is primarily funded from small online donations, and they could have dispersed money, if that was the concern, in the 2-week notice they had. Errors in the reasoning of the divisional court. I'm going to ask you, please, just to have reference to para 12 of our skeleton. We've set out 7. 2 of them I've dealt with at the end, reasons 6 and 7. I'm just going to address you quickly on 5. One, the court applied the wrong test, judgment 58, in saying that the national security context meant that a court should be cautious to supplement these procedural requirements. That's not the test. The correct question isn't when the court could supplement the requirements, is whether the statutory provisions expressly or by necessary implication exclude the common law duty of prior notification. That is the modern law. It's the modern law, Supreme Court Bankmallet, this court in Begum, if you need it, Lord Brown Wilkinson in Pearson, principle of legality type analysis. Second point, the court below effectively reversed and conflated the two-stage test, Lord Neuberger 179. It didn't ask whether the common law duty was excluded by statute and then consider particular circumstances of the case. Instead, and this is really, with great respect, a really deep error, for reasons I'll explain in a minute. What it did is it asked itself whether there might be hypothetical circumstances in which compliance was impossible or impractical with the common law rule. And it reasoned that because there could be such circumstances, theoretically, the obligation didn't arise at all. It used the circumstances of hypothetical cases, not this case, to answer the first Bankmallet question on statutory construction. That is deeply problematic. It's deeply problematic because if you put Lord Neuberger 179 Roman 2, particular circumstances, into Roman 1, Roman 2, the particular circumstances test becomes otiose. There's no application. Secondly, we rhetorically ask, how could hypothetical circumstances supply a necessary implication of exclusion? The third point we make is that as a consequence of this misdirection, it didn't make any finding on the exclusion issue. Necessary implication, exclusion. Fourth submission is affirmative resolution. Sir James doesn't rely on that. Mr. Justice McGarry, 1978 case called Bates, doesn't apply. Modern law's moved on, where you've got a particular affirmative resolution measure which targets an individual, which is what we've got here. That's Bankmallet. He doesn't rely on it. Fifth and last point, the court was wrong to find, this is really illustrative of a very deep error with respect, was wrong to find that any decision to require further procedural steps in this case would necessarily apply to all other occasions when the Home Secretary was considering the use of the power to prescribe. Your lordships and ladyships can conclude that the obligation applies in the present case, but conclude in a different case that it is excluded under Roman 2 of Bankmallet 179. Particular circumstances are picked up case by case. The first question is, does the statute necessarily exclude?
Yes, I think we've got that.
So, and then the point hasn't been made about materiality or anything like that, or section 31. We had a colossal amount to say. My client's statements illustrate that. But just I can give you two examples. Fails. One of the incidents of terrorism relied upon by the Secretary of State. My client could have said, hang on a minute, your police minister in 2023 had assured Elbit that this is not terrorism. That's one example. So, another example is, we are an anti-racist organisation, but that's not really, there's a lot to say. It's not necessary, in this, certainly except in extreme cases, that you disapply this fundamental rule on grounds of no difference or highly likely not to make any difference. I think it's
Well done.
more or less back.
Very good. Well done, Mr. Hussain. Thank you very much. Any questions from you? No, thank you very much indeed. Thank you to everybody on your side of the court. Sir James.
Ladies, my lords, the proposal is in fact that I should address
right. Very
the
good.
discrimination point, subject to the court's view, and then Sir James would have a free run, as
Very
it were,
good.
to
Thank you.
reply and
Article
consultation.
14.
Article 14, we respectfully submit the Divisional Court was right to reject this ground of challenge and right to refuse permission to appeal. Our essential submissions are that the Article 14 challenge faces a series of what we would characterise as insuperable hurdles, and even if you decide each of them in the respondent's favour, the ultimate Article 14 question collapses straight back into the issues you will already have resolved under Article 10 and 11 in the main appeal. In essence, the ground adds nothing, as indeed was the observation of Mr. Justice Chamberlain back on the 4th of July in his interim relief ruling, paragraph 71, Authorities 2, tab 47, page 1647. At best, we submit the Article 14 ground gets to the same place by a route which is both circuitous and legally uncertain. The two bases on which the Article 14 argument is advanced, one developed orally, but I'll deal with both, of course. Firstly, direct discrimination on the grounds of political opinion. It is said that the decision was taken to prescribe Palestine Action, but other, quote, protest groups using direct action for other causes were not. The second, indirect discrimination, here targeting the effect of prescription, which is said has caused disproportionately prejudicial effects on those of Palestinian ethnicity, national origins, and or nationality. Starting with the claim, then, of direct discrimination. Our first objection, my ladies and my lords, is that the respondent cannot establish an analogous group or relevant cohort as a comparator under Article 14. The principled reason for that, we submit, is the nature of the decision-making here.
Sorry, you're dropping your voice.
I'm so sorry, the nature of the decision here.
Right.
We are concerned here with the discretionary power exercised on a case-by-case basis following a multifaceted, individualised assessment. Each prescription decision is taken on its own distinct, fact-sensitive basis, which is either justified as an independent exercise of the prescription power or it is not. The nature of that exercise that we are dealing with here, we respectfully submit, stands in contrast to each and every one of the Article 14 cases that are before both domestic and ECHR. A very short summary of each of them. We don't need to turn them up. But in McLaughlin, Volume 1, tab 26, page 886, the challenge was to legislation denying widowed parents allowance, whereas the claimant had not been married, although had been together for 23 years. SC in the Supreme Court, Volume 2, tab 31, page 1050, the two-child limit introduced in 2016 to the Tax Credits Act 2002. AL Serbia, Volume 1, tab 19, page 551, a concessionary policy applied to certain asylum seekers who'd been in the UK for 3 years or more. AB, that I know my lady, the Lady Chief Justice and my Lady Justice Whipple are very well aware of, the Afghan prosecutor claiming discrimination given the differences between the policies on biometric data with reference to Afghanistan on the one hand and Ukraine on the other. And ALR, of course, legislation removing the VAT exemption for private education. Those both in Volume 2, tabs 36 and tab 48, all of them challenging legislation and or policies. The same exercise can be undertaken with respect to the ECHR authorities as well. The short point, as identified by the Grand Chamber in Carson, which we have at tab 52, page 1949, paragraph 51, is, as is said there, as with all complaints of alleged discrimination, it is concerned with the compatibility with Article 14 of the system, not with the individual facts or circumstances of the case, and see to the same effect the observations of this court in AB. Article 14 challenges are about differences in treatment between cohorts in relatively similar situations. They do not involve individualised assessments. That's paragraph 57, volume 2, tab 36, page 1306. Here we submit we are dealing only with a series of individualised assessments made on the basis of the discrete facts assessed on a case-by-case basis. We are not, we respectfully submit, in the territory of cohorts or systems, rules or measures. I should add, we were taken this morning to the Belmarsh case, which is in our authorities bundle. That, of course, was a challenge to Section 23 of the Anti-Terrorism, Crime and Security Act 2001. So again, a challenge to legislation. We respectfully submit that what you cannot do in this context is seek to establish a cohort for Article 14 purposes by isolating one aspect of the factual matrix, i.e. the concerned in terrorism test, and pointing to other groups who might share that characteristic but are not prescribed. We submit that if that were permissible, then the burden on the Secretary of State would be, in practice, impossible to discharge. Test that we respectfully submit in this way. The most recent challenges before POAC to prescription have concerned, the two most recent have concerned the Tamil Tigers. That is the only organisation in Sri Lanka that has been prescribed. There are, though, no doubt, other organisations in Sri Lanka that are, quote, concerned in terrorism. Islamist extremist groups, no doubt, I assume, right-wing, left-wing extremist groups, etc. Some of those may well be concerned in terrorism themselves. Indeed, some other organisations have been identified by other jurisdictions as terrorist organisations. And of course, given the nature of terrorist activity, which inherently has a link to the purpose of advancing a political, religious, racial, or ideological cause, you're necessarily going to be in a realm of categorisation that engages Article 14. But the fact we submit that the Secretary of State has only prescribed the Tamil Tigers can't give rise to a complaint by reference to other organisations that she hasn't prescribed on the grounds of Article 14. And indeed, the working assumption must be that there are such other organisations because others have identified them as terrorist. That would be an impossible burden, and it undermines, we respectfully submit, the flaw in the respondent's analysis, because this discretionary power to prescribe is not exercised against Group A instead of other groups, Group B, etc., or even exercised by reference to an overarching analysis that looks at all the actions of all relevant groups as a whole and then decides only to prescribe some of them, and still less is there a commitment or policy to prescribe all groups concerned in terrorism. Instead, as I've said, each is taken on its own distinct fact-sensitive basis. And we respectfully submit that that is the beginning and the end of the Article 14 analysis, quite rightly identified by the Divisional Court in its judgment at paragraph 144, the Secretary of State entitled to look at each organisation on its own terms. Even though if you are against the Secretary of State on that position, we respectfully submit that the materials that are relied upon to demonstrate that there is a comparator here, materials relied on by the respondent, do not establish a comparator for the purposes of Article 14. The highest the case can be put for the respondent is by relying on the community impact assessment we have in our bundles, Bundle 1, Supplementary Bundle 1, 10E, page 191, Electronic 200. But the only references that you'll see there, and they're on page 191 and pages 197 to 8, or Electronic 200 and Electronic 206 to 7. The only references that you'll see there are references to similar direct action tactics. That was rightly recognised and properly recognised by the community impact assessment and those who conducted the report. But the short point is we submit that none of those observations are sufficient to establish a comparator for the purposes of Article 14 in this context. None of them amount...
Can I just check?
Of course.
In putting it into the framework, yes, you can go straight to justification, but if you stop at the various routes, destinations en route, one issue is whether or not groups are in a materially analogous position.
That's right.
And that's the bit that you're relying on in relation to Just Stop Oil and the other ones, is it?
That's at the moment, yes. I'm going to get to justification as well.
I appreciate that, yes. But at the moment, when you say no comparator, you mean
yes.
Not a materially analogous. And on whom is the burden of proof in relation to showing that? You or the other side?
At this stage, it's on the other side.
Right, okay.
It shifts when we get to justification. And yes, I recognise, of course, there are authorities to the effect that this can be an arid exercise, i.e. looking for the comparator. And there is, of course, in AB, a reference to looking to get to the focus quickly on justification. However, we do respectfully submit that each of those identifies that there may be cases that it can be clearly seen that the comparators fall outside the scope of Article, or rather the issue falls outside the scope of Article 14, or there are very obvious differences between the comparators. And we do submit that there is a proper point here as to the nature of the exercise that's being engaged in by the Home Secretary. But on the group, my Lord, referring to the tactics, the similarity of tactics, we respectfully submit doesn't amount to a comparator group for the purposes of Article 14. None of those observations amounts to an assessment that the Home Secretary reasonably believes that they are concerned in terrorism, which we submit would be the beginnings, what would be necessary for the beginnings of a comparator. There's in fact no suggestion of violence in the description in the CIA report. Still less, of course, any consideration of the 5 discretionary factors relevant to the Home Secretary's decision-making. The fact that they employ, quote, similar direct action tactics, we respectfully submit doesn't establish them as an analogous group. Compare and contrast that assessment with the detail in the JTAC report, the assessment surrounding the underground manual, the escalatory trajectory of seriousness, etc., all of which we respectfully submit operates at this stage to remove any comparator group as between, on the one hand, Palestine Action and Extinction Rebellion, Just Stop Oil, etc., on the other. And we respectfully submit again, the Divisional Court was right to identify that distinction at paragraph 144 of its judgment. But even again, if you were to take all of those points on behalf of the respondent and move to the question of justification.
What about paragraph 145? There's another issue. You've got a number of questions. Materially similar position on grounds of race, religion, political and so on. 145 says that there was no indirect discrimination or direct discrimination. Are you relying on that or not?
I'm going to come to indirect discrimination.
You're going to come to it. 145, just indirect discrimination.
That is how I read it, but let me just... Yes,
Okay.
because it's a reference to race or national origin, I'm assuming that's...
Right, all right.
And I'll come back to that.
That's fine. So you're on to justification. Sorry.
On justification, not at all. On justification, we respectfully submit that when one looks, in fact, at in particular, the March ministerial submission, the 26th of March ministerial submission, we do submit that one of the key strands of the analysis that was before the Home Secretary was the issue of whether there was a proper basis to distinguish Palestine Action from other so-called direct action groups. It was introduced, and you see it introduced, in the MinSub, page 147, electronic 156, paragraph 10. You'll see there reference to there being no known precedent of an organisation described on the basis of concerning terrorism, mainly due to its use or threat of action involving serious damage to property. That's paragraph 10, page 147, or E156. And a recognition the decision to prescribe will be relatively novel and unprecedented. And in essence, we respectfully submit that set up the issue for the Secretary of State in this context, which in fact was the question: what's the justification for prescribing Palestine Action when there is no prescription of, for example, Extinction Rebellion, Just Stop Oil, etc.? And that is a theme we respectfully submit that runs through the MinSub, as it had been at the pre-RG, as reported within the MinSub. So I don't think I need to take you through all the references, but I'd invite the court to look at paragraph 18, in due course. Reference to the distinction of Palestine Action responsible for an escalatory campaign of direct action that has crossed the threshold into terrorism. Paragraph 19, a recognition at the PRG level that the public and international perception that counter-terrorism powers are being used disproportionately, the impact on certain communities. Paragraph 37, the PRG agreed there was a risk that the general public and international partners will question the proportionality prescription. They will likely ask whether PAG's activity is really terrorism. Similarly, 39, 41, and through to 53, a reference there to the overall narrative about Palestine Action being similar to that of Just Stop Oil and their activities. And they appear to be viewed as such by the media, criminal but not terrorist. So we do submit that when you get to the question of justification, that was, in one sense, the heart, at least the heart of part of the exercise before the Home Secretary, reflected in the ministerial submission quite properly, but also in the underlying reports. And that's, in fact, the proper context of the CIA report. And there's reference to in the Foreign and Commonwealth report on the fifth factor, recognising again some European countries may also question our decision on the basis for prescribing, and rather that it's an activist or protest group.
So in a sentence, if you get to justification, you've got two groups that are similar. I know you object to that, but
Yes.
say they're both similar, and the argument is you've picked on one and not the other, you've banned one, you haven't banned the other. What, in a sentence, is the justification you say emerges from this?
That they've crossed the line into terrorism, that they're responsible for an escalatory campaign that is increasing its risk, therefore, to national security, that the existing features of the criminal justice system aren't sufficient adequately to deal with the risk.
Back to fair balance, you see.
And exactly, as I was, the submission I'm about to make is that entire strand of analysis and evaluation is going no further than the issues already considered under Article 10 and 11, which is why we respectfully submit that ultimately it simply collapses back to where we are already. And in this procedural context, you'll have, if we're here, you'll have decided already that it's proportionate to prescribe Palestine Action, and the justification for so-called singling out Palestine Action will be within the justification under the Article 10, 11 challenge proper. So we do submit a legally far less certain route to the same question and the same answer. I can take indirect discrimination much more quickly. The issue on indirect discrimination resolves to the question as to how is it that any indirect discrimination is ultimately resolved? How is that issue ultimately resolved? We do have, I should say, our preliminary objection as to whether you can properly evidence any differential treatment. That was identified by the Divisional Court, paragraph 145. We stand by that, and the conclusion there, we would support that. But even if you're over that hurdle and you're into the question of how do you justify what has been found to be indirect discrimination, that again collapses back into the Article 10 and 11 issues. Because in indirect discrimination, what has to be justified is the measure. And if we need that, it's in ALR, that's the private schools VAT exemption case, paragraphs 127 to 128, Authorities Volume 2, tab 48, pages 1731 to 2. You have to justify the measure, and we respectfully submit that that takes you straight back to where you are already under proportionality, Articles 10 and 11, with respect to the main ground of appeal. That is, I think, all that I need or want to say on discrimination, unless there are any questions.
Thank you very much indeed. Yes, thank you very much indeed, Mr. Watson.
Just by way of reply, in relation to the policy issue, you can go back to that if you can cast your mind back into that space. I wanted to make three short points by way of reply. The first is the focus that my friend sought to place or replace on the reference to the need for there to be a, quote, particular need to proscribe, derived from paragraph 91 of the judgment. And our answer to that, as I'm sure you're already aware, is that there is no such wording in the policy. And there is no basis for implying any such wording into the policy. What the policy in fact did was to acknowledge that there was a second stage beyond the organisation being concerned in terrorism. That second stage therefore involved a discretion, the may in the Act, and involved proportionality. And it was right to do so. And the correct approach thereafter is that in relation both to the discretion and to proportionality, I'll come back to the meaning of that word in a second, the right approach is that all relevant circumstances that bear on proportionality or discretion can be taken into account and fall to be taken into account. There's a slight difference potentially between the common law, discretion and proportionality under the ECHR, that matters not terribly for present purposes. And that is to emphasise that under the common law, the factors that are taken into account by a decision maker can encompass all of those that the Secretary of State or other decision maker might rationally conclude bear on the policy, but it doesn't terribly matter. And all of those other factors are included in other factors in the policy, as you will recall. You do not, therefore, under the policy, need to demonstrate some special need. There were, in any event, in this case, as you know, matters or factors that went beyond, and that were taken into account, that went beyond simply whether or not Palestine Action was concerned in terrorism. There were other factors. There was, for example, the fact of escalation. There was, for example, the nature of the other activities in which the organisation had been involved. Criminal, not criminal, injury to people. And there was, by way of final example, the underground manual. And my submission is that other activities must include, and properly does include, matters beyond simply those specific actions that founded the conclusion that the organisation is concerned in terrorism. That's the first point. The second point is to register a query, really. I'm not entirely sure where my learned friend's case got to in relation to all of this. At one point, he seemed to be accepting that particular need equals proportionality. It was the same thing as proportionality. I don't really understand that submission anyway, because proportionality, as we're all very well aware, is a necessary precondition to the fulfilment by the public authority of its duty under Section 6 of the Human Rights Act in a context such as this. So what my learned friend then sought to do, I think, was to say, well, you have to interpret this reference in the policy to proportionality as meaning something going beyond what proportionality would mean in the ECHR sense. It imposes a higher hurdle, a stricter test for the Secretary of State to surmount, imposed, or rather self-imposed by the Secretary of State through the application of the policy. But we respectfully submit that any such suggestion would be untenable. And I ask simply rhetorically two questions. How on earth can you interpret the policy so as to achieve the desired Hussein effect? In other words, that proportionality when referred to in the policy means something stricter than ECHR proportionality. And the second question, rhetorically, is even more practical, it might be thought. Why on earth would the Secretary of State self-impose that? That's the second point. The third point is that the real concern here with the Divisional Court's judgment, if I can cut to the chase of it, the real concern here is that the way in which they analysed the policy ultimately led them to two things. The first of them was to limit the Secretary of State's consideration essentially only to matters that are concerned in terrorism. And in relation to that point, justem generis if you want some Latin, but in relation to that point, it is now conceded orally by my learned friend that that part of the judgment was wrong.
Well, he concedes that the similar nature bit was wrong, but he doesn't concede the terrorism point.
Yes, well, my lady, my submission is that other factors in the policy is premised on the organisation already being concerned in terrorism, so they must refer to something additional, and does. That's the answer of substance if that submission is maintained. The second thing that their construction or interpretation of the policy led the divisional court to was the exclusion of any consideration of operational consequences or the advantages of proscription. That's the paragraph 94 point. And of course, the difficulty with that is the usual one, which is that the policy doesn't say any such thing, and there's no proper basis for implying that into the policy. But there are principled objections to that approach. And the principled objections include the point that I think my Lord Justice Edis put to me when I was opening the appeal, which can be summarised as being for and against. Relevance is a neutral business. And it would be very odd if something, an organisation was concerned in terrorism and the Secretary of State considered the advantages or disadvantages and decided that the disadvantages outweigh, but that was a mandatory irrelevant factor, which is essentially what this argument comes to. And my submission is that it cannot possibly or sensibly be treated in that way as irrelevant or excluded under the policy. That's all I wanted to say about the policy by way of reply. I turn to Articles 10 and 11 then. And I'm going to come back to both of these points when I consider proportionality, because both of them echo into that world as well. But I'm going to start with the Article 17 submissions that were made. My submission is that Palestine Action, that is the organisation itself, and its activities, and what it encourages others to undertake on its behalf, are beyond the pale. And you get that particularly in relation to the ECHR from the analysis from paragraphs 82 onwards in the Attorney General's reference case. This is not just under the statutory scheme damage to property alone, as I think Mr. Hussain at one point put it. The statutory test is serious damage to property. And the Court of Appeal have analysed the ECHR aspect of all of that in the Attorney General's reference. I make no further submission about that. So far as the supporters are concerned, of course it is right that not all supporters engage in the terrorist activity which Palestine Action has engaged in. My submission in relation to supporters as a group is that they are not within the scope of the protection of the Convention, because it is no part of the scope of Articles 10 and 11 to allow people to support, and by the various forms of support that are prohibited under our legislation, to encourage an organisation properly and compatibly classified as terrorist under the domestic legislation. And the vice of that support and encouragement has recently been very clearly acknowledged by the Supreme Court in ABJ. I'm not going to invite you to turn it back up, but this time the paragraph is 103 in ABJ in the Supreme Court, tab 49, page 1820. And we would add to that encouragement and support bit that it also involves people, if they trespass on those prohibitions, it also involves people committing criminal conduct under our domestic law. So that's essentially the basis on which we mount that more extreme version of the Convention argument that says they're outside the scope. As I say, both of those points will chime, even if that's wrong when one gets to weighing and assessing the different sides of the balance for proportionality and fair balance purposes. I turn to less intrusive measures. The question, as I think we're all agreed, is whether or not any of the measures that might be suggested by a person challenging a decision would be as effective. You can put that as effective concept in a variety of different ways, as it has been in the case law. I'm perfectly content to accept no unacceptable cutting across the legitimate area. It comes to the same point. My core point is that it's a relative concept. Answering that question, once you recognise that it's a relative concept, involves assessing risks and working out how best to tackle an organisation that has been engaged in terrorist activities. And those are, of course, questions of judgment, ultimately, and assessment for the Secretary of State on advice. And for that reason, this judgment call also attracts margin. It was submitted by Mr. Greenall, who made the submissions on this aspect of the case. Two submissions were made, I think. First, this matter wasn't considered, he said. My answer to that is twofold. That's irrelevant for the purpose of the convention analysis because of the long line of cases that culminated in Lord Hoffman's famous judgment in misbehaving. A substantive breach of the convention focuses on the substance of the measure and its effects, not on the procedure by which it was reached. Second point is that it's perfectly clear that the possibility of alternative, less intrusive measures was considered. It was considered specifically in the CTP report that I took you to in opening. You'll remember the bit headed existing legislation and then the bit saying benefits of proscription. For your note, that's in the supplementary bundle, hard copy 175, soft numbering 184. And that considered, as you will recall, the range of criminal offences, criminal damage, offences under the terrorism legislation that didn't require prescription, criminal behaviour orders, serious crime prevention orders, all of that, and then compared and contrasted those with what you would get if there was prescription, advantages or disadvantages. It was also considered in the ministerial submission of the 26th of March, and again, I don't go back to that, but I remind you of it. Paragraphs 33 and 34 in particular of that. Same bundle, hard copy page 150, electronic page 159. I wanted to give you one other reference because this issue of less intrusive measure was dealt with rather more fully below, at least in writing, and there was a little section of about 5 or 6 paragraphs in our skeleton below to it.
There was also an issue, which is not relevant, but indicative perhaps, of whether or not you could just prescribe Palestine Action London.
Yes, I think that
Remember, a partial prescription.
Yeah, I think
That was also rejected as being impracticable.
it was, and you'll see a few of these
Yeah.
different ones being thought about. Can I just give you the reference to our skeleton below? It's paragraphs 50 to 56. And the reference to that is core bundle, hard copy 276, electronic version 430. That'll take you, I hope, to paragraph 50 of our skeleton below. And that little section on less intrusive measures deals in a little bit more detail with some of the options that were then being put forward. You will recall from the analysis that the key benefits that were perceived of was the availability of the range or suite of powers and prohibitions that enabled action to be taken and prohibitions to be imposed that went to the organisation, if I can put it that way. So there was a particular benefit perceived in relation to dealing with those matters in that way, as it was called, I think, by the CTP, holistically. But you will also recall that the Secretary of State had advice from her experts, the PRG, the CTP and others, that there were benefits, and this was the way to go. And I come back to the fact that that therefore engages margin, engages issues of judgment, and so on. I'll only from Mr. Green will renew before this court was the point that he majored on below, which was in effect the combination of criminal offences and civil injunction. Criminal offences suffer from the difficulty that they are necessarily ex post, necessarily backward looking, and do not enable the sort of holistic attack, as it were, on the organisation's capabilities.
I think Mr. Sorry.
So sorry.
I think Mr. Greenall was referring to the offence of conspiracy as an offence which could be committed and proved before there had been any actual criminal act.
My lord.
Such investigations do tend to be quite intrusive.
Yes, and sometimes quite difficult, and you've got to work out who's conspiring about what and all of that. So I fully accept the caveat, as it were, in relation to conspiracy and its forward-looking nature, that it comes with those difficulties. Again, these are judgments. But civil injunctions, I respectfully submit, are very difficult for my learned friend to rely upon. There are myriad effectiveness issues. They are complex. They're likely to involve and have to involve private companies, whom, as my lady pointed out, my lady Chief Justice pointed out, cannot be compelled to take action by the Secretary of State. So this isn't state action at all. Sometimes the state can assist in various ways, but litigation is ultimately driven and directed by private companies if they can be persuaded to do so. And of course that's rendered all the more difficult when you factor in the context here. You will remember from the documentation the disparate range and increasing range of targets that Palestine Action was going after. And that, of course, enhances the difficulty and complexity of seeking to address any of these issues through the civil injunction route. The reminder is to JTAX report, paragraphs 49 to 50 in the supplemental bundle, 166 in the hard copy, electronic 175 in the supplementary bundle. That's less intrusive measures. Can I come to fair balance? The question, ultimately, is whether or not prescribing Palestine Action is an action which struck a fair balance applying the margin. Palestine Action is the core focus, and my submission is that the answer is very clear indeed in relation to Palestine Action. My learned friend opened his submissions, Mr. Hussain opened his submissions, by in effect maintaining the constant plea to civil disobedience being an appropriate descriptor or analogy. That is untenable, I submit. You have, in relation to that, the judgment of the divisional court itself, paragraphs 21 to 23, giving the lie to that description and specifically rejecting it. Can I just invite you to go back to the case that he seemed to place principal reliance upon, which was the Margaret Jones Authority. In the authorities bundle at tab 1717, and it starts at page 478. And he simply referred you to what he described as the classic paragraph of Lord Hoffman 89, which is at page 519. Can I just invite you to cast an eye down 89 itself, because the seeds of the point I want to make by way of reply are contained in that very paragraph. And the reply point is there are limits, as is evident from paragraph 89, but you see that very clearly if you read the judgment as you have to, both before and after that paragraph. Go back, for example, to paragraphs 83 identifying the mechanisms which the citizen is legitimately entitled to take in the second part, making the very clear statement that the law will not tolerate vigilantes, and referring to the circumscribed nature even in relation to the person defending his own property. 84, second sentence, citizen not entitled to take the law into his own hands. The rule of law requires that disputes over whether action is lawful should be resolved by the courts. Citizen is dissatisfied with the laws laid down by the courts. He must campaign for Parliament to change it. and even clearer when you see the paragraphs that follow and expand on the nature of the limitation that was inherent in paragraph 89 itself. You need to read 89, I'm not going to invite you to do it now, but you need to read 89 with the qualification, if you will, the identification of the limit in paragraphs 91 to 94 on page 520. And in effect, what is being said is that the limit is commission of crime. And the reason the limit is the commission of crime is because there are other mechanisms, proper mechanisms in a democratic society, for raising issues of concern, political or otherwise. To that debate can now be added the ECHR context and analysis that we saw when looking at the Court of Appeal's judgment in Attorney General's reference number 1 of 2022, Lord Claimant's judgment in that case, and I don't go back to that. But it's on the same theme. What are the limits that the ECHR imposes on all of this? So it's entirely unsurprising, I submit, that the Divisional Court in paragraphs 21 to 23 decided as they did. So that's the disobedience, civil disobedience characterisation. Linked to that, and perhaps the second point in relation to Palestine Action, that side of the scale is dealing with Palestine Action itself, you have all of the references that I gave you, almost all unchallenged, in the judgment itself, in opening the facts when I gave you the title, The Nature of Palestine Action and Its Activities. I'm not going to go back through that, but you have all of the facts that I identified there as giving you a proper flavour of the actions that Palestine Action had chosen to undertake, including, I would add, if I may identify 3 paragraphs in particular for your repeated consideration, 29 to 30 of the Divisional Court's judgment, and in particular 137, where they describe in 137, it might be as well to just briefly turn that up to remind you, 137 of the Court's judgment. And in particular, it's the passage from halfway down that paragraph, the line beginning 2000 Act. You see the sentence, any such action is the antithesis. From there to the end of that paragraph is a key summary. Just by way of responsive points to the points that my learned friend made, I wanted to make 3 responsive points briefly on the facts as they relate to the activities of Palestine Action. The first is that my learned friend, Mr. Hussain, sought to maintain a case that the government did not previously think that the terrorism test was met in relation to Palestine Action. And my answer to that is that any government is entitled to review and to re-review a question of that kind. And we note in particular in that respect that the evidence on which the Secretary of State and the advice on which the Secretary of State acted before prescribing included a detailed analysis from JTAC and a detailed analysis from the CTP, the Counter-Terrorism Police. But whether any of that is necessary is questionable, because there is no dispute now, and there never has been a dispute on behalf of those who represent Palestine Action, that Palestine Action's actions did indeed meet the statutory test, in fact. And I made the submission in opening that the 3 incidents that were particularly relied upon for that purpose were supplemented by the Bryce Norton incident, Bryce Norton incident being important in its own right, but also important because it indicated the tempo of escalation that had been predicted before it occurred and then came to pass.
Mr. Hussain lays great weight on the 3 out of 385 and the length of time over which the incidents took place. Do you say anything about that?
My lady, I do. I'm going to come back to Bryce Norton in a second when I've answered my lady's question. But the incidents in question, I respectfully submit that an organisation can involve itself in terrorism in a serious way, despite the fact that it's conducting a load of activities outside that may or may not fall within that definition. And what matters is that they have done so. You have the divisional court's findings in relation to all of that, including that they weren't aberrations. They weren't either a mistake or an aberration. I go back to paragraph 137. And I go back to the point that those actions were lauded by Palestine Action and were the subject of encouragement by them, as the divisional court found. So I respectfully submit that it's not the numbers that matter so much, but the nature of the incidents and whether they meet the tests that Parliament has laid down. So far as the age is concerned, no doubt there will be some cases, and in some contexts it will be more relevant than others, where a particular allegation, or for example, a particular piece of intelligence is very old and therefore falls to be discounted accordingly. But these incidents are not in dispute, and they exist in combination, and they sit alongside the escalation, they sit alongside the underground manual, and they sit alongside all the other activities on which reliance is placed. Just back to Bryce Norton, if I may briefly, that incident did not feature in the JTAC assessment for the obvious reason that it occurred after it. And there was no need, therefore, formally to rely upon it, but it undoubtedly was relied upon. Palestine Action themselves claimed the glory of it, if that's the right way of looking at it. They claimed responsibility for it. And it was evident.
Of that? Where's the evidence of that?
I'm not sure it's ever been in dispute, that. I'll see if I can get you a specific reference to that. But it's clear in any event that it was a serious incident, and that is how it was characterised in our skeleton below. I think my learned friend thought to say, well, there's never been any reliance by me or my client on the Bryce Norton incident. And he referred you, I think, to paragraph 59 of our skeleton below. But again, without wishing to be too tart about it, you might choose to read paragraph 60, which directly follows it, which refers to the Bryce Norton incident and the seriousness of it. The reference to that is core bundle, page 279 in the hard copy, page 432 in the electronic. Yeah, the evidence that describes, I think I gave you this reference earlier, the evidence that describes the Bryce Norton incident and Palestine Action's involvement in it is in Sinclair 2, never controverted, Sinclair 2, which is in the supplemental bundle, number 1, and the hard copy page number is 42C. Get you in 1 second the electronic number. Can someone get me the electronic number? Page 45. 45 in the electronic. 45 in the electronic numbers.
Sorry, what were we looking for?
We were looking for the for Sinclair 2 describing the Bryce Norton incident. given you the reference already to the ministerial statement
Yes.
that announced the thing in core bundle, tab
Acceptance
18.
by Palestine Action, though, is concerned with.
Yeah.
That's their post.
So that's the first point by way of response. Second point is to remind you simply of the divisional court's findings in relation to the underground manual on which my friend sought to place some reliance.
So, James, just before we go there, could I just ask,
Yeah.
are you saying that the Bryce Norton incident was itself a terrorist act, or merely that it was evidence of an intention to continue and escalate previous behaviour?
My lord, I'm not sure we've ever really come off that fence. It could
No.
be either. The only reason I'm reluctant to come off the fence is because we haven't got the formal assessment that we had in relation to the other three from JTAC. But I think we described it in paragraph 60 of the skeleton as obviously a serious act of damage. And it doesn't terribly matter for my purpose whether it's one or the other, unless one starts drawing strict distinctions between those acts that have been formally characterised as concerned in terrorism and those that haven't, which I respectfully submit cannot be right.
Thank you.
The second responsive point was to deal with the underground manual, and it was simply by way of reminder. See judgment of the Divisional Court, paragraphs 23 to 27. And the third responsive point was to indicate, and perhaps it's on the same, it's really on that same theme about some things being on one side, some things being on the other. It doesn't terribly matter where you put them ultimately, if they are seriousness, because you'll be aware that at least in relation to some of the incidents, there were serious concerns about violence against people. You'll recall the sledgehammer incident, and you will recall particularly that the passage that my learned friend took you to in the supplemental bundle, just go back to it very briefly if you would, just to remind you, at electronic page 242 in the first supplemental bundle. That's hard copy page 233. And this, as you will recall, is in the counter-terrorism policing report, describing the various incidents. And my learned friend, Mr. Hussain, took you to the passage notionally by the second hole punch, so it's the last paragraph that isn't blanked out on page 242 electronic. This is a step up. And as I think my lady lighted upon and reminded my learned friend, this was indeed a step up, so illustrative of escalation and perhaps the porosity of some of the lines between characterising serious action as one type of thing or another. But also, and perhaps of some real significance to note, is the paragraph 2 above that, right in the middle of the page, beginning in summary. And I think if that is put as an example in combination with the second half of paragraph 137 of the Divisional Court's judgment, that rather provides the answer to the question my Lord Justice Edis posed to my learned friend. Which was, these aren't isolated incidents, these are matters of real seriousness. So it's against that background and backdrop that I made the submission, and I repeat the submission by way of reply, that the assessment that is undertaken under the policy, under the convention, matters not, encompasses and must encompass both the activities that fall within the definition of terrorism and other activities, the entire range of activities, for good or ill, but the entire range of activities, mostly ill, we respectfully submit here. But the latter, the range of activities outside that statutory definition, of activities outside that definition, are in principle relevant. Unsurprising they should be so, because the fundamental purpose of the prescription regime is protective And of course, those other activities and a broad assessment of what the organisation does is central to a proper assessment of risk. And risk is the determinant of the protection of the public for present purposes. And on that facet, we do submit that it's of particular importance that all of the experts advising the Secretary of State concluded that prescription was appropriate. All concluded that the actions of Palestine Action were escalating in seriousness. Tying it back to judgment paragraph 137. All were concerned about the way in which they conducted themselves, including through publication of the underground manual, the cell structure, the violent activity being encouraged, and so on. It is no answer to that concatenation. It is no answer to that to say that many of its activities were, to use the wording of the divisional court, quote, merely criminal. Merely criminal would put it beyond the pale for the purpose of the domestic common law. See Lord Hoffman and Margaret Jones. And if you're dealing with violence or criminal damage above the merely trivial, that would put it beyond the pale for the purpose of the ECHR. See for that purpose Attorney General's reference. And that is why we respectfully agreed with, and agree strongly with, the description of Palestine Action's actions and activities in the round by the Divisional Court at 137, describing them as the antithesis to the notion of a democratic society that is the foundation of the ECHR. That's the position in relation to Palestine Action, therefore. That's one side of the scales, if I can put it that way. The other side of the scales is the impact on supporters. But it's important perhaps to identify the right question when you get there, because it's Palestine Action that is being proscribed. The question at this stage is whether if viewed by focusing on the subject of the prescription, namely Palestine Action, the answer is clear, as in my submission it is, for all the reasons I've gone through. Is a different answer required under the Convention because of the possible effects on others? That's ultimately the question. And I want to make 2 points in relation to that. The first point is that all of the reliance on the impact on supporters, if I can put the groups in that broad way, were, as the Divisional Court themselves found, considerably overstated by those presenting Palestine Action's case. And I gave you a whole series of references yesterday to passages in the judgment that reflect that, including, I may add, and I'm not sure this was one of the list, the conclusion at paragraph 118 of the Divisional Court's judgment that the correct conclusion in relation to those holding up the banners post-proscription was, quote, calculated action. But as importantly, the other chilling effects were, they concluded, overstated. And I would add at that stage that the category that my learned friend Mr. Hussain then sought to rely upon in his oral submissions in particular were those who had not been members or supporters before, and they wanted to advocate for its deproscription. And the answers in relation to those are, first is that they have no prior attachments to the organisation itself. And that's a point that's important for a reason I'm going to come to when I do my second point. No prior attachment to the organisation itself. But secondly, that it's perfectly possible to have a debate about deproscription of an organisation compatibly with the law. ABJ being the font of all knowledge, can I give you 2 further references into ABJ for that purpose? Paragraphs 47 on this specific point about whether you can call for someone to be deproscribed, leaving aside the technical point that says if you can demonstrate that you're a supporter or you want to get it deprescribed with a sufficient interest, you can apply yourself to POAC or to go down that road. But ABJ 47 and 79 are the paragraph numbers in ABJ for this purpose, and you find them at 1804, electronic, and 1813. That's the first point, considerable overstatement, proper reflection of the true degree to which impact actually happened, found in the judgment of the Divisional Court unchallenged. Second point, and this is absolutely critical, I respectfully submit, it is necessary in the convention analysis when considering the impact on others of the prescription of an organisation that has involved itself in terrorism to be very, very clear about the distinction between support for a cause and support for an organisation that might be involved in orchestrating or organising protests in support of that cause.
And that is para 61 of ABJ.
Para 61 of ABJ, but support, I make the more general point that the support for the, it is 1661, ABJ, no, it was ahead of me, but support for the cause is the core of the protected right. The
Sorry,
free
say that
speech,
again. What does that mean? Say that
that
again.
means that the free speech that is truly at the heart of the protection that Article 10 provides is the speech that advocates changes to policy, political speech, indicating public approval or disapproval of various matters. That's the core of it. That is the broad political speech and issue that underpins Article 10 and indeed the freedom of assembly right in Article 11. That's at the heart of it. And that core is untouched, absolutely untouched. You can continue to advocate anything to do with that. That's the point that the Supreme Court was making in 60 to 61 LBJ. So what are you left with in terms of impact and weight to be accorded to these rights? You're left with support for the bare organisation. And we know you can't do that post-prescription. But that is because Palestine Action is justifiably viewed as proscribed with the legal consequences that Parliament has judged to be appropriate. But it's very hard to see why, properly separated and distinguished from the cause, much if any weight is to be attached to the mere support of the organisation. It is simply a strident advocate for the cause that you continue to be. You can continue to be a strident advocate for on your own or through some other organising body that organises marches or whatever else it may be. It's very much the point I was discussing with the Master of the Rolls yesterday, when you put to me essentially this distinction, and I respectfully...
But I think the problem, or the point that I was putting to you, is that whilst intellectually you might be able to make the point you've just made, the people who support Palestine Action and hold up the placards with those words on them don't understand the distinction and are affected inevitably by prescription. And what I was putting to you was that that is something the Secretary of State had to take into account, that we're dealing here with real people who are affected by her decision. And I'm not saying it's a conclusive factor in the balance, but it seems that it is, and I think you accept it, it is a factor.
Well, I do accept that that's a factor. I'm not sure that's quite the point I was accepting yesterday, but I'm perfectly prepared to accept that it was a factor. One needs to be a little cautious with going too far with it, because if they're holding up the banners post-proscription...
As a calculated action.
That's a calculated action.
That shows signs of a very clear understanding, not a lack of understanding.
Exactly
but
so.
There may be people who genuinely don't make the distinction and aren't taking calculated steps. That's the
and it's a real effect here, because there has been, as you will have seen from references in the judgment and in the evidence, there's been quite a concerted campaign to swamp the courts and all of that. So they're trying. There's a deliberate attempt to undermine things in that way. So I don't need to resort to the idea, often referred to in these cases, that everyone is presumed to know the criminal law. But because the fact of the matter is that when they hold up the banners of the kind that my Lord has identified, and they would no problem with holding up the banners beforehand because they weren't prescribed, but after they're prescribed, you've got a finding that it's calculated action.
So
My point isn't a bare intellectual one, if I can come back at my Lord in that respect.
No, I understand that. The other point is that Mr. Hussain made quite a lot of the fact that there were only 3 incidents. My lady's already slightly put it to you, 3 out of 390. And everybody else, he implies or infers, is not involved in terrorism, concerned in terrorism. And the question I wanted to ask you concerned what you said. I think it's paragraph 19 in the divisional court's judgment. They said, I may have got the paragraph wrong, where they said that information about how Palestine Action is organised and run is sparse, and there is no information about membership. I think membership is mentioned in 18. The extent and nature of Palestine Action's membership and organisation is largely unexplained. And I just wanted to know whether you relied on any other evidence about, it's all very well to infer that if there's only 3 terrorist incidents, there's only a few people, I think Mr. Hussain said 45, 35, I can't remember, people involved. What I wanted to ask you is, where does that evidence come from? It doesn't seem to be challenged.
Where does the evidence in paragraph 19?
18 and 19, that there's nothing, that actually, when the court considered this case, they didn't have any evidence about the 400, 500,000 people who may have signed up in
Well, it was
some way.
Mr.
on
Ammori's
Twitter.
witness statements.
The Morley's witness statement, I think in part, you'll see the description in the second sentence of 19,
Right.
this coming from the claimant, and the second half of that paragraph
Yeah.
in relation to the cell structure and the deliberate attempts to keep it, as it were, difficult to penetrate, it comes from the underground manual principally.
So it's a comment on those pieces.
It's a comment in effect on those, or it's a conclusion from those pieces of evidence. But I mean, the point remains that there are, as it were, the 3 that were classified, incidents that were classified, but they were serious, and I've made my points about the porosity that may exist between criminal damage of a seriousness when you're encouraging them. You've got all the findings that say these weren't isolated, they were encouraging them to do, in effect, violent things, and don't be surprised if violent things spill over into other violent things. So it's all of that we rely upon. But ultimately it comes down to essentially the same core point, which is a point about risk analysis and how best the public protection is to be achieved. And that does absolutely squarely fall within both squarely raises both the importance of the expert advice that the Secretary of State gets and the importance of the Secretary of State being democratically accountable for the protection of the public. So the outcome in my submission, ultimately, of all of this, is that it is very clear on the left-hand side, when you look at Palestine Action, what the answer is on proscription, or at least what an acceptable within the range of margin answer might be. And that in the light, in particular, of all of the detailed findings that have been made by the divisional court about impact, and when one bears in mind the distinction that I've just drawn, which is a real rather than a purely theoretical one, in relation to impact, you end up with a pretty strong balance in favour of proscribing and protecting the public that way. So that's how we put that part of the case. I wanted to turn briefly to the cross-appeal, the prior representations point. And I start with the principles, if I may. My submission is that prior consultation is an aspect of fairness. The governing principles are indeed, therefore, those 6 features of a fair process identified famously by Lord Nussbaum in 2D. what fairness requires when statutory powers are being exercised is context and fact specific. And as Lord Sumption himself acknowledged in paragraph 31 of Bank Mallat, such imposing a duty of prior consultation in relation to decisions made under such powers, quote, cannot be answered in wholly general terms. The test in effect identified in Bank Mallat for determining whether there is a duty of prior consultation has two limbs. The first of them involves an exercise of statutory interpretation. Does the statute expressly or by necessary implication exclude the obligation to give prior notice and an opportunity to make representations? That's the issue on which the Supreme Court divided with Lord Reid in the minority for that purpose. Alternatively, if the duty is not excluded, do the circumstances in which the power is to be exercised render it impossible, impractical, or pointless to afford
You
such
say
an
the
opportunity?
divisional court effectively decided it was implicitly excluded. Question one.
Sorry,
Do you say that the divisional court implicitly concluded that the statute necessarily excluded the
yes,
duty
and
of
also,
prior
yes, is the
consultation?
answer to that. And
I mean,
also,
they referred to the right test at the beginning. That's your point. It is a bit less clear.
it is, and then
The
but then
later section of the judgment.
yes, there's also a bit of an element in my alternatively bit, i.e. the impracticality and
yeah.
so on,
Yeah.
coming from Lord Newberger 179. And my ladies at least will need no reminding of the application of those principles in the Begum context, including the important aspect of the context there being the need.
And what do you say in Begum where there was a right of appeal? What do you say without there being a right of appeal here?
Well, my lady, my submission is that the principles you identified and the approach that you took there, 106 to 108 in particular, didn't ultimately turn only on that. It was a broader question of context. And of course, we don't say that the factors are identical here. Of course, they're not. You were there dealing with a deprivation of citizenship and in particular the risk that the person would come back covertly, I suppose.
You're also dealing with specific people. In Bank Mallat, it was one bank.
Yeah.
In Begum's case, it was Miss Begum herself. Here, you're dealing with a disparate group.
That was a very important point.
Yes, there's no corporate structure as such.
That was a very important point that the divisional court placed reliance upon. Can I
Where
come
did
back?
they sorry, yes, do, but where did they do that? Just in their
It's really 58 and following.
Okay.
I'm sure I'll get to the references to that
Yep.
specific one if I may. I was going to start with the point about the identification of the principles by the divisional court. And my respectful short submission in relation to that is that they correctly identified the relevant principles. See paragraphs 47 to 55. And I'd say no more than that. I respectfully submit that's the correct identification of the principles, and then they come on to identify the factors as they bear on Palestine Action at 57 and following in the judgment. And again, my overarching submission in relation to that is that they were perfectly entitled to reach the conclusions that they did. They observed that the context in which the statutory power in question was being exercised was a critical consideration. That's 58 of their judgment. And that was a conventional application of the requirement in duty that fairness must be assessed in all the circumstances. And in Bank Mallat, that it depends on the particular circumstances. The statutory context here involved national security and public safety and
But
protecting.
do you accept Mr. Hussein's point that there's no blanket waiver when you're looking at national security? It's a factor.
It's a factor.
But yeah, okay.
You can't just turn up and say national security. That's it. But it is a very important factor, both national security and the protection of the public aspect of it. And my submission is that the divisional court were entitled to and correctly took into consideration that context. It meant, as they found at 58, that they should be cautious before supplementing the express procedural requirements imposed by Parliament. They were correct to note, I submit, in 58, that any decision to require further procedural steps in this case would necessarily apply to all other organisations when the Home Secretary was considering use of the power to prescribe an organisation.
Well, Mr. Hussain says no. He says that in this case it did, but in another case perhaps there wouldn't be a requirement.
Well, my lady, I'm not sure it's quite as simple as that. My submission is you are entitled to, as I think you did in Begum, you are entitled to acknowledge that this is, if you're looking at the statutory interpretation point, this is ultimately a question of statutory interpretation that will apply. Do you imply it or don't you? You don't imply it sometimes, as it were. And so there is that more general element. It doesn't mean that you don't go on to consider the facts here, and it doesn't mean that the divisional court didn't do precisely that. They did go on to consider very specifically the facts here. But it is important to bear in mind that ultimately this is an issue of statutory interpretation of general application.
You're meant to treat like cases alike. If you've got an organisation like PA, and it's enough to pick one person who was one of the founders, or a spokesman whose email you've got, and that's enough, and it's not unlawful because you haven't contacted all the founders or all the people on the emails, then if the same facts arise in another organisation's case, you'd have to do the same, presumably.
Yeah. Well, those are the sorts of factors that they then go on to consider. The nature of the organisation in question, the organisation here concerned in terrorism, the extent of possible communication, the possible reaction of the consultee, the difficulty in practice of consulting an organisation of this kind. All of those matters which I respectfully submit are relevant to and bear on the fact-specific aspect of this question. And they led to the conclusion at 63 that the factors weighed heavily against the existence of a right of the kind indicated. It's also to be noted in that respect that they also identified in 62, halfway down, the possibility of preemptive steps, and my learned friend Mr. Hussain referred to that, in relation, for example, to the movement of funds.
But he says that there would always be that opportunity due to the affirmative resolution procedure. There's always going to be time, he says.
There may always be time, but the mere fact that you have more than a scintilla of time doesn't undermine the force of the point. It might take a while for people to clock it, it might take a while for people to react and to do things. But the position under the various bits of legislation that bear on this is that once an organisation has been proscribed, funds can't lawfully be raised or used for the purpose of that organisation, nor can any arrangement be entered into which facilitates the retention or control by the organisation.
But his point is that it's built into the system here. They will always know what's coming because they can't just make it and announce it. It doesn't take effect until it's approved by affirmative resolution by Parliament. They'll always know about that. Yeah. And if there really is a problem, they're going to switch the funds overnight. There's the emergency procedure, or the urgent procedure, forget what you called it.
My lord, there is. There's the urgency procedure, and there's the practical point that they may not be set up in quite the way that would enable them to react in that way.
Well, they might not read Hansard, I suppose.
They might not read
Hansard. We don't know what's going on.
But anyway, there is a point there about preemption in any event. So we respectfully submit that's of some importance, and they note that at 62. They also particularly place reliance on the practical difficulties of inviting prior representations, identifying who should have been given prior notice. I think that's 65.
What about 61? Which is the process of consultation. It's the nature of the information on which one's consulting. And the need for caution, and whether or not you could just sort of tell the whole story and ask for what sort of consultation would it be?
Well, my lady, I respectfully...
You share all the information, all the intelligence that you had, clearly not all of it, some of it.
You certainly couldn't do all of it, and then you'd have to do summaries, and you'd have to do everything else that is associated with this sort of context. I mean, they are all legitimate points. You might think that none of them is in itself conclusive, but my core point is that there's nothing wrong with this analysis. They're looking at the right things, they've identified the right principles, and they reach what I respectfully submit as the conclusion they were entitled to reach. and that doesn't involve any reversal or conflation or difficulty in relation to the approach that was adopted. They're doing faithfully the exercise that the case law identifies should be done. Look at the statute, look at the features that bear on the statute, and go to necessary implication. Look at the practicalities, look at the difficulties with doing it, and the difficulties here are myriad, and they are the ones that the divisional court identified. So my submission, in short, is that they were entitled to reach the conclusion they did on this issue for the reasons they gave. That's what I say by way of reply to that point. That's me done.
Well, wait and see. Thank you very much indeed, Sir James. Anybody on your side following at this stage?
I
Not
hope
even
not.
anybody from
I
the
hope
second
not.
row?
I might have failed badly enough for that.
Right. Thank you very much. So, Mr. Hussain, reply on the cross appeal.
Reply on the cross appeal. I'll start with due process, if I may. And I want to make an overarching submission, and I mean it without any disrespect whatsoever to Sir James or the court. The court's approach and Sir James's submissions are entirely unprincipled. They get the test 100 degrees the wrong way round. Sir James said he embraced the court at 58, saying that you've got to be cautious before supplementing. A lot of the submissions were directed at, well, should the court really supplement? That's totally wrong. Even the old language about the court supplementing the omission of the legislature doesn't help, because the issue is, when do you do it, or when do you find that the right is implicit in the statute? And the answer to that question is that you find it's always implicit in the
I
statute.
thought your case was it was implicitly excluded. You
No.
say the foundational rule
Yes.
is that if something's going to affect you adversely, you should be entitled to consultation. And that's why the first duty question is, did the statute necessarily exclude?
Exactly.
All right?
The starting-
it's necessary exclusion.
Exactly. The starting point is, it's there. If you're an ultra vires theory of judicial review person, you say it's implicit there. You're giving effect to the legislative intention. You're reading general words as if they include the right. If you're a rule of law judicial review theorist, you say the common law supplies it. Doesn't matter whether it supplies it or whether it's implicit. The question is, when isn't it there? And it's the starting position is it's there or it will be supplied, not is there good reason to supply it. It's is there compelling reason. As a matter of logic, Lord Hobhouse in Morgan Grenfell, a necessary implication is a matter of logic and interpretation, not expediency, not reasonableness.
Did he say logic?
Yes,
Right.
yes, he did. We haven't got it here. I read it some time ago. But absolutely, he says logic. Because it's got to be necessary. It's a strict test. Because what you're doing is using general words to cut across a fundamental right in the technical sense, a basic right in the technical sense. It attracts the principle of legality, this common law rule. Statutes are presumed to respect the common law. You don't legislate in a vacuum as Parliament. That's Lord Brown Wilkinson in Pearson. It's really basic stuff, certainly in the modern law. There are earlier, older authorities which are not so clear about that. But we have, I thought, it was common ground, Bank Mellet. It couldn't be clearer. 179191 of Lord Neuberger. The exclusion has to be clear, not the reason to include it. So it's totally the wrong way around. First question. Second question. The second point. Sir James said this twice. The question isn't whether or not the divisional court were entitled to reach the conclusion they did. It's whether they were correct, because this is a question of law. Short point. And then, my ladies, my lords, there are some there's some extraordinary reversal and emptying of the Lord Neuberger 179 test. If you look at whether or not it's going to apply in hypothetical circumstances, you have emptied 179 Roman 2 of application, because that is the test that picks up individual cases. The first limb of the test is what I've been going on at you about at over length in this submission. It's necessary inclusion. And it's absolutely heretical to suggest that if you imply it in this case, you've implied it for all. Sir James embraces paragraph 58, where the court says this. It would be necessary to apply it to all organisations. My Lord Justice Lewis says, well, you would find that there was a co-founder of another organisation. If you found the co-founder of Al-Qaeda, you might just have a reason on the facts of the case to say, no, I'm not going to tell them.
But your
Well, it's got to be
starting point
that's
would be that
that's
for any organisation, the presumption is you consult them, and if there's somebody whom you can consult, then you do consult. That's the point. You can't start again in each case, can you, and ask again, is it a good idea? Should it be excluded or not?
Well,
The
that's
starting
a-
point is there's got to be a reason on your analysis.
Yes, the default rule, the very strong default rule, is you consult. This is a draconian a power as you could get. And my lord, the other point of distinction that you were trying to sort of raise with Sir James, or did raise with Sir James, is that, well, in these other cases you've got an individual, here you've got a group. You've got an individual here, my client. Her rights are dramatically interfered with. And then you've got everybody else. The position can't be worse as far as the common law rule is concerned if you've got hundreds of thousands impacted than if you've just got one.
Yeah, but the question is, will it be lawful? Is it lawful to consult one founder but not the other founder? That's the difficulty. I mean, are they going to...
That's a practical question. 1792.
What's the answer in this case? Is it unlawful?
No,
because-
it's the answer in this case, absolutely not. Those are my instructions, I'm sure.
Well, they both.
And we've said it. My lord, this is 1792. You deal with practicalities, difficulties. Oh, well, let's say there are 10 co-founders. Do you have to consult all of them? Are they going to say different things? It's impossible to raise them. Well, you do your best, and B, if it's impractical, Lord Neuberger, 1792. What does he say in the final sentence of 179? You've got to be very slow to exclude the duty to consult under Roman 2 by reference to the particular circumstances, because by that point the statute hasn't excluded it by necessary implication. So really, what's gone on here is a reversal of the correct approach. Begum, a couple of points on that. 2 points. 109 is key. Your ladyships say that what SIAC had done was to underrate the importance of the appeal. The appeal was very important. Second point, Begum is Morava territory. It's absolute Morava territory. If you give notice, the point of what you're doing is gone. This statute is very different. It's very different because the delay is built in, and Parliament has said when you've got a problem with the standard procedure, no doubt because it will give rise to give notice of what you're about to do, use the urgent procedure. How can that, by necessary implication, exclude this fundamental right? This is a very important point. Just because you've got a terrorist context, we say marginally engaged, it doesn't mean you just forget about this fundamental protection. On the contrary, it's where you should be most live to honouring that tradition. It's quite extraordinary set of submissions, if I may say so, on a very, very important point. Those are my submissions on that ground. On the discrimination ground, 4 points. Firstly, sorry if I'm repeating myself slightly, the reliance by my learned friend Mr. Watson, King's Counsel, on the nature of the decision is heretical. Prescription, presumably all discretionary powers fall to be exercised on a case-by-case basis. To put that beyond the reach of equality law, we say is obviously wrong. Second point, he says, well, the cases concern systems and cohorts. Well, Belmarsh concerns a decision to detain some people, suspected international terrorists, as defined by Section 21 of the Act, and not others. Second point. Third point, it's not an impossible burden. In any event, it absolutely doesn't arise in this case because the Secretary's own advice was that these other organisations employ, quote, similar tactics for the purposes of proscription. And if there wasn't an assessment about the level of violence, the level of damage they cause, well, that is evidence of discrimination, not an answer to it. The fourth point, the ministerial submission says nothing whatsoever about comparators, doesn't even attempt to justify the difference in treatment. The submission ignores the difference between justification of the measure and the justification of the differential. And that's a profoundly important difference in equality law, in our law. And where is the evidence? If that's the case, where is the evidence, please? Where is the evidence? We didn't think they were analogous. And by the way, they're not for these reasons. You had the opportunity, you sought the opportunity to put an evidence, you didn't avail yourself.
And I think we had that.
You've got the point. I'm so sorry.
No,
Last
don't
point.
don't worry at all. Don't hurry. It's absolutely fine.
Last point. On these two grounds, we don't have permission. This is a rolled-up hearing. I would ask you, please, to grant us permission, whatever you do, in terms of the substance, not least because we would say the submissions are good. We'd say at least they have real prospects of success, but we'd also say that there's a compelling reason. And your ladyship and my lords may remember why that's so important, as Lord Justice Lewis reminded me at about 10 p.m. on that day, the 4th of July. If this case goes further, then whether or not you've granted us permission on these grounds, it is important.
Anything else?
Those are my submissions.
Anything else? No, thank you. Thank you very much indeed, Mr. Hussain.
Thank you.
Anybody else fancy standing up at 4:10, having a go? No. Well, we need to deal with some housekeeping and some reporting restriction issues, but it's the right moment to thank everybody in court for all their hard work, for their very helpful written and oral submissions. And could I also take this opportunity to thank all of the court staff who have been magnificent in preparing for such a big hearing, and indeed our clerks and everybody behind the scenes. We have had a veritable tsunami of documents and emails and materials. I'm sure it's been hard work on your side, but it's also been hard work on those who support us in the work that we do. So we are all very, very grateful indeed for that. So unless there are any other matters, before we turn to reporting restrictions, of course, formally we should say that we will be reserving our judgment. We have a closed hearing as a matter of public record tomorrow morning. That must start promptly at 8:30 because one member of the Constitution at least will have to leave court at 10:30. So please make sure that everybody is really ready to go at 8:30 tomorrow morning. We will, as I say, reserve our judgment. We will keep the parties informed. There will be the usual processes to go through in terms of any closed submissions or material, and we will keep the parties informed as best we can. Obviously, there is an awful lot for us to think about. We are aware of the urgency. We'd be very grateful for Sir James if you could keep us informed of any developments in Scotland, that may be relevant to timetabling or other matters. Are there any other matters in terms of housekeeping or procedure that anybody would like to raise? And can I just check with my lord and lady, is there anything I need to deal with? Yes. Yes, we'll get there. Yes, we'll contact the parties in due course when we have a clearer idea of how we're going to deal with hand-down arrangements. Yes, well, we may well not be handing down anything under embargo. If we do, you don't need me to emphasise the importance of compliance with the embargo, and a failure to comply with the strict terms of an embargo can result itself in criminal offences. So, as I say, we will keep in touch closely as to what arrangements we make for hand down. Right. Reporting restrictions, James.
Just before you get there, I've been asked a rather fundamental question, which reads, how will we get access to the court tomorrow?
Yes, so I've got, well, I mean, that's a mere technicality, Sir James. I have a whole raft of emails asking me complicated questions about who's going to do what, when, where, but let me see if I can find a relevant one, which
Dig a tunnel now.
says, I understand that you will all have access. I have a list of people who are coming. I believe that there will be access from 8 o'clock.
At the West Green entrance?
Correct. I'm sorry, I'm having a blank. I can't find the relevant document.
Melody, don't worry.
Can I make sure that the communications by email have been working well? Have they otherwise, Mr. Hussain? To those instructing you, they're all coming through. In which case, I'll make sure that by 5 o'clock this evening, something coherent in terms of practicalities is sent out. But I have seen something which says you will be let in by no later than 8 o'clock at the West Green car park and take us out. We're in court 27. So not over in 72, in court
Melody, with your
27.
permission, I'm going to leave you in Mr. Blundell's capable hands.
Yes, so you won't be coming, Sir
I'm not.
James.
I won't
Right.
miss you.
Well, I can strike you off the list, which is already looking inaccurate then.
Thank you.
My ladies, my lord, can I just, on behalf of the respondent, just thank everybody, the court staff, and of course my ladies and my lords, for accommodating a two-day hearing and then sitting at this extraordinary hour tomorrow.
Well, thank you. That's very kind of you, Mr. Hayne, and Mrs. Hayne, and much appreciated. Okay. Where are we on reporting restrictions?
Well, my lady, I'm afraid we've still got some fairly strong resistance from prosecuting counsel
Right.
to the removal of what struck us as being one possible way of doing it to give effect to the indication you gave.
Right. Who is prosecuting counsel?
Paragraph C. It is,
It might be Dean.
forgive me.
My Lord Justice Edis thinks it's
Is it Miss Here?
Yes, it is.
I thought it
Exactly.
right. Well, I think well then, and she's not here, and you're not in a position. Is there anybody here in a position to advocate, identify the issue? Right.
And then I think the concern is that we've been having email exchanges to try and give effect to the order and the indication that you gave, and the difficulty is it's quite difficult to make proper and helpful submissions to the court if you're not actually involved in the trial process. But I understand the jury are about to go out or aren't far from going out, and the real concern is that even recognising there is a public judgment out there, the repetition or the possible repetition in the press at this time of that would be problematic. But
All right.
I don't want to undersell it.
No, I understand. Well, I think the documents that came in this morning were no doubt well intended, but they were not particularly helpful.
No.
Because they were out of date. There was one updating note. There was no draft order, and certainly at speed, speaking entirely for myself, I was unable to identify the precise scope of it. And as importantly, the press and any other interested parties have not had an opportunity to digest. So I think the sensible thing would be, and I'm going to look in particular to my Lord Justice Edis. I don't know how Miss Here is positioned, but I think we would like a simple note with a draft order that can, by perhaps 10 o'clock tomorrow morning, if that's acceptable to her, she can do that, that should be served on the press, who were involved in the original order before Mr. Justice Chamberlain, served on the Press Association, I would suggest, at the same time as it's lodged with the court. any written submissions that anybody wants to make should then be with us by 10 o'clock on, by 10 o'clock on Friday, and we will endeavour to resolve the matter on the papers.
Can I pause?
Mr. Hussain, do you have any particular interest in any of this?
I was looking at people behind me white, and I got a shake of the head at the moment, but we'll
Okay.
certainly,
But obviously you'll be included in any
thank you, and then we'll be
that
able
are
to
served.
we'll be able to make representation.
Are we safe for the time being? We are, because the order's in
I think we're safe
place.
for the time being if it's overcovered.
Yes.
I suppose that the people whose interests we're concerned with are those who are on trial, and perhaps they ought to be given an opportunity to supply any written observations that they want to do through their lawyers who are conducting the trial on their behalves.
Shall I invite Mr.
Yes, which makes 10 o'clock tomorrow morning look a little unrealistic.
Down? Perhaps we
So
give
let's say 4 o'clock tomorrow afternoon.
for all submissions by
Yes.
any council involved.
Yes, and any draft order. Are you okay with that? And
Yeah, I'm just thinking that we really want to have the order that is proposed by prosecuting counsel first, and then any other submissions from anybody else by 10 o'clock on Friday.
yeah. Well, it should be 4 o'clock on Friday because it's all slipping away now. But if they're not going to come in till 4 o'clock on Thursday, I imagine that Miss Glass and others from the press would like at least 24 hours to consider the position.
Yes, my lady, 24 hours would be ideal.
Thank you.
So I haven't quite got the sequence in my head at the moment.
So today is Wednesday, Sir James.
Thank you very much.
By 4 p.m. on Thursday, we would like a short written note from the prosecution
Yeah,
with a draft order, ideally with defence submissions alongside it or endorsing prosecution note. By 4 p.m. on Friday, same week, Sir James, press will have the opportunity to respond, and we will make our minds up as soon as we can after that. Is that it? Is that all right? And you'll serve the Press Association tomorrow, 4 o'clock, by 4 o'clock. Obviously include Mr. Hussain and his team. And if there are any particular immediate problems, I am delegating to Lord Justice Edis as point of contact in the first instance. Is that all right? All right
Yes.
with you all?
Yes.
Thank you all very much. For those of you who we will not see tomorrow, farewell. And for those of you we will see tomorrow, we look forward to seeing you there. Thank you all very much indeed.
All right, people. All persons having anything further to do before my ladies and lords in the closed proceedings may now depart and give their attendance tomorrow morning at 8:30 a.m. in 87. God save the King and my ladies and lords.
Thank you.